And the next case we have on the docket is 23-2944, Christopher St. Cyrin versus Markeisha English. Did I say that, both of them right? Okay, my lucky day. Okay, thank you very much. Go ahead, you may proceed.
Good morning, Your Honors. May it please the Court, my name is Catherine Weiler, and I represent Defendant Appellant Christopher St. Cyrin in this appeal. Mr. Cyrin is entitled to a new trial. Florida courts of appeal have regularly warned, in negligence cases, directed verdict on causation is seldom appropriate, and there's good reason for that general rule. Negligence cases are often centered on questions of credibility, of the parties, of the treating physicians, of the experts, even of the lawyers. And this case is no exception. That's why the trial court's order granting plaintiff a directed verdict on causation necessitates reversal. But it's not the only reason. Based on that order, the trial court instructed the jury that contrary to the defendant's arguments, plaintiff was injured as a result of the June 21st, 2018 accident.
Well, let's leave the arguments for a second. Let's just talk about the evidence.
Yes, Your Honor.
So Dr. Silas admitted that there was a sprain or a strain resulting from the accident. Is that
Dr.
correct?
Silas acknowledged there may be temporary injuries that were caused by the accident. That's correct.
Temporary injury, but an injury nonetheless.
That's correct.
And admitted also that the injury was caused by the accident.
Dr. Silas acknowledged that it may be caused by the accident. That's correct, Judge.
And the directed verdict was not on the question whether the accident was a legal cause of permanent injury, but rather only whether the accident was a legal cause of injury of any kind.
And I want to have this precise. I'm trying to answer the court's question, if the court will bear with me. I believe that's correct. The directed verdict was that the accident was a legal cause of the injury. And I want to have the language precise.
Right.
That's right. That's why
I can tell you because I looked at that very closely. At first, I thought the judge had directed a verdict saying it was the cause of the injury. He did not say that. He said of injury, loss, injury, or damage.
Yes.
Not even and certainly not permanent. So just injury, plain, simple injury, which again, that's one little word is a big word. And I think the judge was quite careful on that. And even during the hearing on the motion for a new trial, that was discussed in detail as to what the judge did direct a verdict on. And the parties agreed to leave question one on the verdict, and that was there negligence on the part of defendant that was a legal cause of injury, loss, damage, or injury to plaintiff? And the jury could have said yes or no at that point.
Well, at that point, Judge, two things. The jury did have the ability to say yes or no. The instruction is the problem. The fact that the question remained on the verdict form is not the problem. It's the instruction. And with the court's permission, I realize that we all are trying to be very deliberate about it. I do have the language in front of me. If I can just read it, because I agree with the court. That is what is so fundamental here. The instruction that the court read to the jury: the court has determined and instructs you as a matter of law that the motor vehicle collision of June 21st, 2018 was a legal cause of the loss, injury, or damage to plaintiff Markeisha English. It is for you to follow the rest of these instructions to determine to what extent she suffered injury, loss, or damage. That phrase is where the confusion is created by the court's instructions. And I'll say it again. This is at the transcript, page 1058. I realize the court has that if the court needs the citation. 1058. Again, it is for you to follow the rest of these instructions to determine to what extent she sustained injury, loss, or damage. That instruction reads as if it is a direction to the jury that they must make a determination of damages. You are being instructed to determine to what extent she suffered that injury and therefore to what extent she was damaged. There's not any sort of wiggle room there. There's not room for the jury to evaluate the plaintiff's testimony, the evidence that was given at trial, and to make a determination about credibility. And that is the fundamental problem in this case, credibility. We've talked a lot about the Lancheros case and the Mickler case in our brief. Judge McCarr, you actually in our argument just before this argument asked, what are the two cases that are the most crucial to the issue that you are presenting? In this case, it's those two. It's Lancheros and it's Mickler. And the procedural postures of those cases is relevant to your questions, Chief Judge, and to yours, Judge Pratt, about what exactly, why is this a problem when the court's language was so deliberate and it used that language, a legal cause of loss. It's because of cases, the decisions in Burke and in Mickler, where negligence wasn't an issue at all. Those cases were admitted negligence cases. And even then, in situations in which the jury was not given the opportunity to fully and completely evaluate this question of legal causation, that's when there is a fundamental problem with reversible error. That's the same thing that happened in this case based on the language that the court used in instructing the jury. Again, the jury was told the motor vehicle collision was a legal cause of the loss, injury, or damage to plaintiff. It is for you to follow the rest of these instructions to determine to what extent she sustained injury. As the 6th District has said, as a different panel of this court has said, the jury needs to be allowed to make the determination about whether or not that causation exists in a case, and it has to evaluate the credibility of all of the witnesses in reaching that conclusion.
If the verdict form is fine, why wouldn't you expect the jury to look at the verdict form, and if they wanted to find for your client and say there was no injury, on number 1, they could have easily said no, correct? And if they thought it was a temporary injury, which is what the judge thought he was granting a DV on, if the jury thought it was a temporary injury on question 6, did the plaintiff sustain a permanent injury as a result of the motor vehicle collision? Could have said no there as well.
3
and did
reasons.
not.
Oh, I'm sorry, Judge.
Go ahead.
3 reasons. Number 1 is to your question about couldn't the jury just have said no to the first question. Even the trial court acknowledged they really couldn't based on the court's instructions. This is in the hearing on the motion for new trial. I apologize to the court. It's page 41 of the hearing on motion for new trial. I don't have the citation to the record itself. But the court says, this is the trial court in evaluating this question, quote, "My paragraph in the jury instructions effectively told them to say yes to question number 1 on the verdict form." Even the trial court acknowledged that.
Well, but if I might, then hold your thought just a second. Even if the judge thought they had to find an injury, question 1 still asks about negligence. We don't have that in the Burke case.
That's correct, because negligence was admitted in Burke and in Mickler. So that's why that makes no difference in terms of the court's analysis, because if even, say, the jury in this case found negligence, there was admitted negligence in Mickler and Lanciero. So you're already past that burden when you still have an issue related to the legal cause question.
Again, going back to what Judge Pratt started out with, what evidence was there that she sustained no temporary injury in this accident?
There was extensive testimony from the plaintiff about her history of motor vehicle accidents, about her history of work injuries, and also, I don't want to cut the cord off, and also about her, even post-accident, about her claiming in certain situations, so 2 different work-related applications, the Kindred Hospice application, the Vitus application, in physicians' offices that she had no injury, and then separately telling treaters she did.
Those employment physicals or questionnaires, those were not about were you temporarily injured. Those are you hurt now or do you have a problem now, right?
That's absolutely correct, but I raise those, Your Honor, because, again, credibility. What the jury was able to consider was, based on the circumstances of the June 21st, 2018 accident, where the plaintiff required no additional treatment immediately following the accident, where the plaintiff left the scene saying that she was fine and did not seek out any care or treatment until several days later, the jury can look at those circumstances and make a determination about credibility. In fact, those are very similar to the facts in Lancheros.
Did the plaintiff hide the fact that she had earlier injuries from anybody or subsequent injuries?
She did not disclose certain accidents and circumstances of her health to some of her treating physicians. That is in the record, and that's part of why it's all of a piece of this idea of credibility. It was very much in dispute.
But you admit there's no testimony saying she was not hurt as a result of this accident?
That's not entirely accurate. Dr. Pfeiffer, who was the defendant's...
Well, And again, we've read that. Dr. Pfeiffer, the judge, was very clear in questioning your colleague that Dr. Pfeiffer didn't talk about strain or sprain, in fact, didn't even mention the word.
He didn't mention the words sprain or strain, but
And he
Dr.
didn't-
Pfeiffer, I'm
He
sorry,
didn't
no.
say anything about that she did not have a temporary injury.
He was very clear that based on the imaging, it did not
The
appear.
question to you was, I feel like the trial judge with your colleague now. I asked you a question. Did Dr. Pfeiffer testify that she did not sustain any injury at all in this accident?
He did not.
Okay.
And didn't Dr. Silas testify that she did suffer a sprain or strain?
He did.
And did you ask the jury to disregard that portion of Dr. Silas's testimony?
No, Your Honor. And there was no need to, because under Florida law, the jury has the ability to disregard that testimony if it is in dispute. And it is in dispute from the underlying facts that I just referenced based on the plaintiff's testimony, her own evidence and testimony. It was very much about the credibility of these fact witnesses. That's the distinction here. The trial court was...
Whose credibility do we look at as far as whether she got a boo-boo in this accident?
The jury looks at the credibility of all of the witnesses.
But tell me, we've got these witnesses saying she was injured, at least temporarily, some minor injury, sprain, strain, to the plaintiff's experts saying no doubt about it, she was wiped out. Who's the other contestant here saying no, she wasn't?
And I'm trying to answer that question, Judge, if the court will bear with me for just a minute. It's not just the medical experts. It's all of the witnesses. That's the distinction. So I believe I understand the court's question, and that's, is there any evidence from the medical experts or treaters saying she suffered no injury?
Anybody. Tell me anybody. Tell me anybody in the whole world who testified and said she suffered no injury in this accident.
We can just start with the medical experts. The answer is no. There is testimony that she did suffer temporary injuries. If we look at the lay witness testimony, certainly the only person who can testify about her injuries is Ms. English, and she did testify that she suffered injuries as a result of the accident. But the jury can look at all of the testimony at trial and make a determination about whether or not they believe that. That's the problem with credibility. They were allowed to make a determination based on all of the testimony of record. And that goes back to what I was saying before. Her consistent history of...
Well, if ownership of the vehicle was an issue, and I know it wasn't here, but if ownership was an issue, and all the witnesses testified to the ownership all in the same way, you'd say, well, there's still a credibility issue here.
Not necessarily, Your Honor. Presumably, there would be documentation establishing ownership of the vehicle. In this case, the medical documentation is not completely clear, and that's what I was referring to when I was talking about Dr. Pfeiffer. There is medical evidence in this case that is not based solely on descriptions from the plaintiff or an analysis of exactly how the plaintiff was feeling at a particular given point in time, or based on her own history that she's providing to the medical experts. There is imaging in this case, which you can't really fake imaging, and that imaging that Dr. Pfeiffer testified about, that's why it's so important that Dr. Pfeiffer could say, no, based on the imaging, it does not look like she experienced an acute injury or any significant injury in the days leading up to the imaging that happened right after the June 21st, 2018 accident. So you do have evidence of record that combined does create those questions of fact. Her testimony, the imaging testimony, the jury has to start evaluating the credibility of all of that testimony when it's making a decision about whether or not it believes her story. And that's why directed verdict is so inappropriate in a situation like this. The jury has the opportunity to make that decision. If they agree with the plaintiff's arguments, then the jury will reflect that on the verdict form. But the jury wasn't given that option here. Instead, the jury was told, again, that the rest of the instructions were to be followed to determine to what extent she sustained an injury, not whether she sustained an injury. That's where the error comes in, and that's why a new trial is necessary. That is exactly...
Did you propose an alternative instruction below?
There was not an alternative instruction proposed because, as you see in the transcript, the problem was the directed verdict. And at that point, it was the trial counsel explained, we don't think the jury should hear any of these instructions about the special instruction that the jury, excuse me, let me rephrase that. The special instruction that the court gave the jury based on the directed verdict. That instruction, which is what I was reading to the court, is the problem here. So there was certainly an objection by trial counsel saying, based on we don't think you should have given a directed verdict.
But you objected to this instruction, but did you propose an alternative that
No,
rephrased
no,
it?
Your Honor, because we don't think that the jury should have been given that instruction at all. I see that I'm into my rebuttal time. If I could preserve that.
That's fine.
Thank you, Your Honor.
Good morning. May it please the court?
Good morning.
My name is Brian Lee. I represent Ms. English in this appeal. I wanted to start sort of where counsel ended about the instructions themselves. And the instruction that the court gave to the jury didn't stop at, and you've read this, Judge, this is at page 1058 of the trial transcript. It says, it is for you, jury, to follow the rest of these instructions in determining to what extent she sustained injury, loss, or damage. It doesn't stop there, because the next part says, as a result of the subject collision. So the court did not tell the jury, hey, jury, I've already determined that she suffered loss, injury, or damage. You don't have to do that at all anymore. The judge was very clear in the instructions that I have determined that there was an injury, but that you, the jury, had to determine the extent of that. That goes along with the evidence. Was it a temporary injury? Was it not? Was it a permanent injury? The jury had the ability to determine that all the way through. And they did, because we know what the jury did. We know ultimately that the jury determined causation in this case. The jury found that and the question itself said, was there a permanent injury caused by this collision? So it wasn't, was there a permanent injury within a reasonable degree of medical probability? Was that caused by the collision? And what I've put in my brief, Your Honors, is that you can't have a permanent injury without an injury. Can't do it. And so we know what the jury determined. We know that they determined that there was an injury. They went further and said there was a permanent injury. And so we believe that the trial court was correct in issuing a directed verdict in this case for an injury, because that was what the medical evidence said. That was what the evidence before it said. And I will note, Judge, that part of the argument that we're hearing, or we have heard from the appellant, is that, well, there was these accidents that happened beforehand. She was injured beforehand. There was no secret about that. There was records put in the evidence. But I will note that Dr. Silas, defense expert, said that he believed that there was an exacerbation of those injuries from this crash. So any type of argument that, well, the jury could have found that it was really all these things, that's kind of what happened in Burke. You know, they said, well, it could have happened there, and that's why the 6th District Court of Appeal, I believe, part of it was why they did that. That wasn't in this case, because the only evidence the jury had, ironically, came from the defense doctor. And he said that there was an aggravation, not just that there was temporary injuries that were caused by this crash, but that there was an aggravation of what was there before. So I believe that for a lot of reasons, all of which I'm including in my brief, the directed verdict was proper. But
Well, let me ask you,
Yes, Your Honor.
the standard of review
yes,
that we apply to this, in this situation. I'll just say, as I read the instruction, I was confused. This is the one the court has determined, instructed, in the following sentence, it was for you to follow. That's the instruction I'm focusing on. I was confused because I thought the court had directed not just causation, but also on negligence. It seems to me that you can't just have this stand alone without further telling the jury, it's your job to determine negligence. So, for example, it is for you to follow the rest of these instructions to determine to what extent the parties were negligent and whether she sustained injury, loss, or damage as a result of the subject collision. That part about determining negligence is not there. So standing alone, I read that just in a vacuum perhaps, as saying negligence is not to be determined by the jury. That in some sense, the court is directing that there is already negligence here to the defendant's part.
Sure, Your Honor. Now,
I realize the verdict form says,
yeah, absolutely. Now I'll address that. And the trial court kind of thought that too, right, at the hearing. But I would disagree, because after the part where I read in 1058, it kind of goes into 1059, and it says, the issue on plaintiff's claim, general negligence, the issue you must decide on Makesha English's claim against Christopher St. Cyrin is whether Christopher St. Cyrin was negligent in operating his motor vehicle, and it goes on about the negligence of legal cause, right? So,
well, but I guess my point is that, to me, if I were the trial judge, I'm glad I'm not the trial judge, so they have a tough job, I would have said to what extent they were negligent, and I would have explained everything that the jury then has to determine from that point forward, negligence and then the extent of damages. I
sure.
just think it creates confusion by not doing that.
I hear you, Your Honor, and there, certainly were there other ways that could have been done? Sure. If
well, that's my point. Is we're not here. Are we here on it's a de novo review, right? Are we here to just sort of play trial judge on appeal, or are we just to look at it and say, well, was there really any reasonable chance that this created confusion and error?
Well, I think also that we may be mixing standards of review too, because yes, whether the trial judge should have granted a directed verdict, that's a de novo review, as the court knows. But when we shift over to the jury instructions, that is not a de novo review. That's an abuse of discretion standard, as the court knows. And so you would have. Appellant would have to show that the way that the judge did the instructions, and it's not that whether some juror may have, in a vacuum. It's whether the instructions were reasonable in what they did and what they told the jury, what the jury looked at. And Judge, I think that the facts of this case lend themselves to say that that is not the case. And the reason I say that is, frankly, the same reason I go back to the directed verdict, is that if there was some discrepancy, right, or the instructions themselves were not, should have been done in a different way, we know that the appellant didn't bring that up to the court. These instructions, now I understand appellant's argument that they're saying, well, we didn't want those directed verdict instructions anyways, right? But they never brought up to the trial judge and said, you know what, trial judge, we think that instruction, as you've just read it, we think that's confusing to a jury. None of that was brought up.
I said just the opposite. I mean, the judge said,
yes, sure.
I know you're not waiving anything on this directed verdict thing,
Right.
but about this instruction, is this okay? And trial counsel said, essentially, and I'm not quoting, but yes.
Yes, that's correct.
It wasn't just didn't object. It was affirmatively said, no, we don't agree with the DV, we don't want the instruction, but as far as the instruction itself, since you've given a DV, granted a DV, okay.
And absolutely right, Judge. And we do go, and this is part of the briefing, maybe I can talk about it here, is that there is a preservation issue with that too, right? They didn't object, and as the court and Judge Edwards pointed out, they actually said, yeah, we agree to it, the wording. They didn't include it within anything that they did post-trial either. And now they come to the court and say, well, we think that was confusing. And again, I kind of harken back to what the previous case was. They didn't give the trial judge a chance to change it. This trial judge, I think we could probably safely say, would have taken that into account and probably would have changed it, frankly. But they never brought that up. They never brought up any kind of wording, never brought up any kind of confusion or argument like that. And they allowed that to go to the jury. The jury made their determination. They didn't bring it up post-trial. And so now they're bringing it here. We believe that preservation has not happened, and they can't come to this court now and have this court try to reverse, saying, well, the judge should have given a different instruction, without them having give the trial judge the ability to do that in the first instance. We think that would be wrong. So I hope I answered that, Judge Makar.
The trial judge did, as you said, at 1058 and 1059, tell the jury in the instructions it was their job to decide negligence, And then you had question 1 on the verdict form, right?
Right, Your Honor. And not just that, Judge, as every single trial judge does in a case, they go through the verdict form. And this judge went through the verdict form and said, number one question, ask the question, you could say yes or no, right? I mean, the judge didn't say, oh, by the way, jury, you're going to have to check yes to that because I've already said this. No, he said it's and then he went on and said, if you check no, your verdict form is complete, right? And so it was very clear that I believe, the judge's instructions to the jury that they had to determine that issue. And even if we assume that it wasn't, the defendant, the appellant in this case, certainly didn't come up in closing statement and said, by the way, jury, you got to check yes. No, they had plenty of argument about that their client was not negligent. So to say that the jury was confused that they had to put yes to that first question, it's just not borne out by the evidence or the argument, and it's really not preserved for this court. There are other arguments that I've made in my answer brief. I would rely on those arguments unless the court has any questions for me, but otherwise, if the court has no more questions, I would ask that this court affirm the trial court's decision. Thank you.
All right, thank you very much. And you've got a little less than 5 minutes.
Thank you, Your Honor. I'll try to keep it brief, believe it or not, even within my 5 minutes. I just want to make 2 points in rebuttal. The first is related to this issue about waiver related to objection on the instructions. The point is that the defendants didn't want the instruction given because it wasn't proper to give it at all. So how is a defendant supposed to propose an alternative instruction on these directed verdict issues when the defendant is preserving its objection to the idea that they be given at all in the first place? There's not a waiver because of that.
You're saying this is a confusing instruction.
That's correct.
Did trial counsel tell the judge, no, we don't agree with the DV, but by the way, Judge, this is a confusing instruction?
He did not, Your Honor. Because,
that's a problem, isn't it?
Because the instruction should not have been given at all.
That's fine, but you're not just, you don't stop at that. You're saying this instruction is confusing, and because of that, we should get a new trial.
We're
Yes?
saying, what we're saying, Your Honor, is several steps. That's one of them. The first one is,
But as far, I know, I understand about the DV, and I'm not trying to get you to waive anything either, but in terms of this jury instruction being confusing, that's one of your pegs in your,
Yes, it is.
your game there, if you will. Trial counsel never brought that to the judge's attention that this is a confusing instruction, correct?
trial counsel made clear that trial counsel thought it was inappropriate. Trial counsel did not say, you are correct,
Okay.
the trial counsel did not say it's confusing. That is correct.
Kind of takes that peg out of your board, doesn't it?
It does not, Your Honor, because the instruction should not have been given in the first place. That's the fundamental problem with the instruction. That's why there's no waiver of that issue. I also want to make clear that that is addressed in the post-trial motion. This is at R3654, where defense counsel is discussing why the directed verdict permeated the entire trial and kept the jury from resolving credibility issues. Now, certainly, Chief Judge, you are correct. There is not a sentence there that says the jury instruction was confusing. I'm not trying to suggest that there was, so please don't misunderstand what I'm saying from that record site. But that is a very clear explanation of exactly what I've been trying to explain. It's the same point, that this directed verdict permeated the entire trial, and these instructions are part of that problem. They cannot be divorced from it. That leads to my second point that I wanted to make in rebuttal, which relates to your point, Your Honor, about even when you read these instructions, they were confusing to you. And that is the fundamental point in Poole. This is the Poole case. We've cited in our briefs, Poole versus Lowell Dunn Company. And I just want to quote very quickly from the court, because I think it's exactly the same situation we have here. And the court says at page 53, it's 573 South 2nd 51 at 53, we find that in the instant case, the jury might reasonably have been confused or misled. thus resulting in a miscarriage of justice, unquote. That's the problem here. The jury might reasonably have been confused or misled. If even the court is potentially confused or misled, certainly a lay juror could be. I said I have 2 points. I want to make one last one, so 3 points. The last is related to the standard of review. There was a question about the standard of review. The standard of review applicable to this court's analysis of the directed verdict finding is de novo. And there is a fundamental problem with the directed verdict finding beyond the legal issue. It's a standard of review problem, and that's that the court, the trial court, is required in evaluating a directed verdict motion to draw all reasonable inferences in favor of the non-movement. And in fact, the trial court here did the exact opposite. The reason I bring that up is because it relates directly to this question that we are discussing about Poole. Reasonable confusion, whether these instructions are misleading. Inferences function in a similar way. Certainly it's a different legal concept. I'm not suggesting they are identical. But the directed verdict motion should have been evaluated with an eye toward how inferences should be drawn. They should be drawn in favor of the non-movement. The problem with these instructions is that the instructions that are being given to the jury are pushing the jury in the direction of a finding that the jury should be entitled to make, not the court. That's the problem here. That's why this court should reverse. That's why the defendants are entitled to a new trial. We ask that the court do so. If there are any questions from the court?
No, thank you very much.
Thank you, Your Honor.
We are going to be in recess for a few minutes, and we'll be back in 5 or 10 minutes. So we've got one more matter. And are you Mr. White by any chance? Yes, Your Honor. All right. Well, if you'll just stand by, we'll be back in 5 or 10 minutes. In the meantime, we are going to be in recess. Thank you.